Courtrooms are traditionally places of solemnity and order, where justice is dispensed with careful deliberation.
Teal.
It's not a fair trial. It wasn't in trial. I'm not being allowed to speak how I need to speak.
I'm the judge in the matter. Shut your mouth. Do you understand what it means to...
However, there are moments when the decorum of the court is shattered by unexpected and dramatic events that captivate public attention and become etched in legal history. Starting with a case of Manson Bryant, who yells at judge. In a courtroom, Manson Bryant, a 32-year-old man, faced charges for multiple crimes, including robbery and abduction, in an Ohio court. According to reports, Bryant and a co-defendant were arrested for breaking into a trailer home, holding the resident at gunpoint, and robbing him. This wasn't Bryant's first encounter with Judge Eugene Lucci, who had previously sentenced him to 4 years in prison for a robbery.
So accordingly, the court will sentence on count 1, aggravated burglary, felony 1, count 3, aggravated robbery, felony 1, count 6, having weapons while under disability, felony 3, and count 7, carrying concealed weapons, felony 4. The court did refer to the defendant for an updated criminal record. The court previously sentenced the defendant to prison and at that time had a full pre-sentence investigation done. The DRC shows that the defendant was released from prison on my last sentence of him on November 15th of 2017. Mr. Williams?
No, Your Honor. Thank you.
You may address the court first.
Yes, Your Honor. The court's aware a sentencing memorandum was submitted by the defense prior to today's hearing. I believe the court's summation of the issue of merger largely mirrored what defense had submitted as far as merger of the charges. I would just briefly address the issue of mergers to count 6 and 7, that being weapons under disability and carrying a concealed weapon. While there are certainly circumstances and case law to support, I believe some case law was actually cited in the state's sentencing memorandum where these two offenses have been found not to be subject to the merger doctrine. In those situations, I think it was more so speaking to an individual who actually acquires a weapon prior to commencing a criminal offense and then obviously uses that weapon in the course of a criminal offense. I think here our situation is distinguishable in that Manson Bryant was convicted essentially under an aider and abetter theory. There was certainly nothing to indicate that he took part in the actual acquisition of the firearm by Mr. Bynes. There was nothing to indicate that he actually physically possessed that firearm throughout the course of the crime that was committed here. For that reason, we feel it's distinguishable. The so-called, essentially the possession of the firearm was all part of a continuous course of conduct, and Mr. Bryant was found guilty of those offenses based upon being an aider and abettor to Mr. Bynes in the commission of this act. As to the sentence, Your Honor, obviously the court has at its disposal here, given the number of offenses, the firearm specifications, the court can craft a sentence here that would essentially keep Mr. Bryant in prison until he's a ripe old age. We would only note that retribution is not the only goal of the legal system. Rehabilitation does carry equal weight, and a sentence that would essentially prohibit Mr. Bryant from being afforded any meaningful opportunity to redeem himself and live a law-abiding life would not be in line with the purposes and principles of sentencing. We are asking this court to consider a 10-year aggregate sentence. We feel that would not demean the seriousness of the conduct here and not demean essentially the role as a aider and abettor that Mr. Bryant was found guilty of here. We feel that sentence would be commensurate with sentences that have been imposed by this court for similar crimes and against similar offenders. The court is aware that the principal actor here, Mr. Bynes, did in fact receive a 12-year sentence, and we feel a 10-year sentence is in part for the role that Mr. Bryant was found guilty here in this particular offense, and such a sentence would provide him the opportunity to live a meaningful life and prove to himself and the court that he is capable of rehabilitation. Thank you, Your Honor.
Manson Bryant, the law allows you to say whatever it is you want me to consider before I sentence you. Is there anything you want me to know?
Yes, sir. Your Honor, I know you very well aware of my history. I made a lifetime of bad decisions. And those bad decisions has caused pain to a lot of people in my family. For that, I am truly sorry. Most of my bad decisions have been driven by my addiction to drugs and to do whatever I can to continue to get high. My ability to stay clean has me to spend most of my life in prison. There's no way for a person to live. That's no way for a person to live. And it's not how I want to finish my life. And despite the circumstances of my upbringing, I understand that I can't continue supporting others for my actions and my behaviors. I have become jaded towards court legal system by having this trial was an honest and open fire for me. I have never gone through trial before. I have a newfound respect for the efforts of the attorneys, judges, juries, and role in living as giving the accused person the opportunity to have the case heard. That's all anyone can ask. I am thankful for the opportunity and afforded by the day in court, and I respect the decisions that the juries have made. I alone have the power to end the cycle of incarceration, and all I ask is for you to give me a meaningful opportunity to still make something out of my life, sir. I don't want to die in prison, sir. I'm not a bad person, sir. You have a good life. I've been in front of you multiple times. I respect you. I respect the decision that you make.
All right.
Thank you.
Do you have any witnesses to present?
No, Your Honor, thank you.
All right, let me hear from the state.
Thank you, Your Honor. Just in reply to the merger argument, the state also filed a sentencing memorandum that does deal with the merger issues. And count 6, having weapons under disability and carrying concealed weapons, count 7. Through the case law, they have separate animus and they do not merge. Goes back to the Ohio Supreme Court, many districts. The acquiring versus the concealing of the weapon are separate animus, regardless of whether Mr. Bryant acquired it or Mr. Bynes acquired it. Mr. Bryant was aware of that. They had it in the condo well before they left to do this. They were aware of it, and the need to conceal it makes it different as well. So we do feel there are separate animuses, and there are no reason that those would merge even in this case. Also, there was an argument made that there need to be, I'll get to that. For sentencing, Your Honor, obviously this court has heard in detail the facts of the case. I don't want to go over them extensively, but just looking at the factors in this case, they are laid out in the sentencing memorandum. However, just so the record is clear and others can hear, obviously the victims, Mr. Gonzalez and Ms. Morello, both suffered serious psychological harm. Obviously, Mr. Gonzalez was present as people unknown to him enter his home without permission, terrorize him, steal from him, as the court has made reference to, pointed a gun at him, pushed it against his forehead, pushed him back, threw a blanket over his head, continued to move the gun around his body, feeling it in his rib cage as he was punched in the head. Even when they left, it left a lasting impression to the point that he left that location. He no longer lives there. He didn't feel safe or comfortable there. He was renting that room with Ms. Morello. She has also had concerns because she came home as Mr. Bryant and Mr. Bynes were leaving. She was running late. Had she not been running late, she could have walked into that situation, and she had a young child with her. So she also had psychological harm, knowing what could have happened, what did happen to her friend in her residence. We also have serious economic harm. The restitution request is for $1,298 for Mr. Gonzalez.
Despite his emotional appeal, Bryant was sentenced to 22 years in prison. As Judge Lucci read the sentence, Bryant initially appeared calm. However, his attitude changed dramatically when the reality of the lengthy prison term set in. Bryant exploded in a tirade, expressing his anger and frustration at the court's decision.
The court determines that you have or will have the ability to pay restitution.
Courtroom, you racist. He 22 years. Racist. You ain't.
Judge Lucci responded swiftly to Bryant's behavior. He noted that Bryant's outburst was evidence of his lack of genuine remorse. Consequently, Judge Lucci reconsidered the initial sentence, deciding that Bryant's behavior warranted the maximum penalty.
Last time before this time that I had him, I put him in prison for 4 years for a robbery. He acted out briefly on his way out of the courtroom, and I just let it go.
You never gave me probation.
Wait a minute.
You never gave me a chance.
Well, it was clear that the remorse that he was trying to portray was phony, and that he wasn't remorseful at all, and that if given the chance, if I let him loose on society, he's going to prey on other people.
Manson, calm down, bro. Let me out the courtroom, man.
After listening to Manson Bryant's tirade, Judge Lucci decided to add 6 years onto his sentence.
I love you, bro. I love you, man. I love you, Chad.
So that's 28 years.
I don't want to hear it, man. Let me out. Let's go. Let me out.
on.
I don't want to hear it.
He added 6 more years to Bryant's sentence, bringing the total to 28 years. This decision underscored the judge's belief that Bryant was a danger to society and lacked the potential for rehabilitation. Manson Bryant is a prime example of a convict acting crazy in court, but could getting your mouth shut with tape be considered crazier, like in the case of Franklin Williams? Franklin Williams faced a litany of charges, including multiple robberies and aggravated assault, leading to a dramatic courtroom saga that captured headlines. Williams's legal journey began with a series of armed robberies in 2014, culminating in a high-speed chase that left an officer injured. Initially pleading guilty, Williams later withdrew his plea and fled the state, claiming memory loss due to an accident. Upon his capture and trial resumption, Williams made waves at his sentencing, disrupting proceedings over 60 times in just 54 minutes.
We can do that uninterrupted to allow me an opportunity to place on the record why we're here today. Is that something that we can agree on? Thank you for nodding your head. All right, with respect to today's hearing, the court, after sentence in the courtroom last week, was advised by counsel that in fact we had missed some of the items that needed to be discussed with respect to sentencing. For example, the repeat violent offender specification, there was some prior conviction, there was some additional verdicts that needed to be read with respect to the bench trial that was held by the judge, by myself during that trial. With respect to that notice being provided to the court is in a situation where the sentencing had never really taken place. I had not signed any journal entries regarding the sentencing. And in fact, looking at legally and the responsibility that I had as a judge legally, I found that having a re-sentence of the matter would be what was inclined to have to take place, having to go through that process all over again, and having an opportunity for the state to speak, and also an opportunity for you to speak, to have that evidence presented. As a judge and a lawyer, I've spent my whole career, almost 26 years, with the bench, public communities, public groups, and bar associations doing one thing, which I always found to be important, is promoting confidence in our justice system. I'm concerned that the hearing last week eroded the trust that I worked so diligently with others to build. In retrospect, while there is legal precedent for gagging a defendant to keep order in the court, I apologize for taking that action last week. My decision to end your outburst came after I had exhausted every other attempt to restore order to a hearing that you continuously impeded. Despite many warnings for you to stop your frequent and offensive outbursts, I believe it was over 60 interruptions in 54 minutes, you continue to interrupt and hinder the legal procedures of the court. Procedures that are designed to protect your rights, the rights of the victims, and our justice system. It escalated to the point that as a judge, it was my responsibility to take control of the hearing. As the court is the foundation of justice and fairness, a judge, such as myself, has the responsibility to maintain control of the legal process that occurred. Knowing that a defendant is required to be present at all times during a sentencing, I acted with those principles in mind. And the sheriff, they followed their department policies and procedures in order to restore the order that was happening in court and to proceed with my hearing. There are many questioning whether those actions were just or fair. However, the sentence that I ordered, I believe, was even-handed and impartially imposed, and based on the facts of your crimes, the impact on the victims, as well as the need to protect society from further criminal activity. You were convicted by a jury, and the jury convicted you of aggravated robbery, kidnapping, all while you used a gun. Now, while you faced a potential maximum consecutive sentence of 134 years, I ordered a 24-year sentence. Due to your many criminal violent acts, the 3 victims that you held at gunpoint have had to live in fear for several years. And I continue with that hearing despite the disruptions in order to give closure so that they could heal and move forward. That decision may have had the opposite effect. And for that, I apologize to those victims. To my colleagues on my bench here in Cuyahoga County, and to the 700 judges in the state of Ohio, I regret any impact or repercussions for my actions last week. I never want the fairness and justice that each of you deliver in your courtroom to be questioned, no matter the circumstances. The judge has a moral and ethical obligation to avoid the appearance of impropriety. In this case, the sentence I imposed was not final, and typically, the case would come back to me for further action.
Despite Judge John Russo's repeated warnings, Williams persisted in speaking out, disregarding the court's authority. Judge Russo's frustration boiled over as he threatened to gag Williams with duct tape if he continued his interruptions. Williams' defiance reached a climax when Judge Russo ordered court deputies to silence him with duct tape. In his next sentencing hearing, Russo later apologized for his decision and recused himself from the case.
I've had to silence him because of his disrespect for the system, disrespect for the parties. Mr. Williams, I'm the judge in the matter. Shut your mouth. Do you understand what it means to don't talk? Don't talk. Mr. Williams, be very simple to gag you.
It's not a fair trial. It wasn't in trial. I'm not being allowed to speak how I need to speak. He's stopping me from talking. He's gagging me, putting tape over my mouth at this moment.
So when they put the tape on my mouth, I felt so humiliated. I just felt like, wow, it's an abuse of discretion of the courtroom. Listening to the duct tape go, I still hear that at night. Because the judge would not allow me to talk and get the things that I was trying to say, on record. He would stop me before I was able to be able to explain anything on my behalf. Yes, sir. I was hit in the head, and I didn't receive no medical treatment. I lost my mind. I lost my memory. I don't even remember me going to a trial. That's what I was trying to tell them. And I just was so concerned about if my children seen this, if my family seen this. I feel that my constitutional right of freedom of speech has been violated.
However, Judge Russo, considering Williams' extensive criminal history, sentenced him to 33 years in prison. But before Williams left, he had some final words.
All right, so we're back on the record. So, Mr. Williams, as I was leaving, I heard that you wanted to make a statement, and so go ahead.
Freedom of speech, no duct tape.
Anything else you want to say?
Freedom of speech, no duct tape.
So I'm giving you an opportunity to speak. What would you like to say?
That's all I gotta say, Your Honor. Freedom of speech, no duct tape.
Very good. I just wanted to...
If you thought that was bad, this is because you didn't hear about this case where a man attacks on his attorney, Christopher Teal, who was in the King County courtroom where he faced serious sexual assault charges in Seattle, Washington. Reports detailed a disturbing incident where Teal, described as a homeless man, allegedly followed a woman into a restroom at a Volkswagen dealership and assaulted her. Company employees intervened, leading to Teal's arrest on charges of first-degree sexual assault and unlawful imprisonment. During a competency hearing, Teal, represented by his lawyer Reed Birkland, displayed erratic behavior.
Matter of State of Washington versus Christopher Teal, cause number 181-008-391. Hugh Barber for the state. Defendant is present in custody with counsel. This is a defense motion to move the trial date to which the state has no objection. I'll defer to counsel and, if necessary, ask for a brief opportunity to respond.
Your Honor, this case has been going for quite a while. There is ongoing expert work. All the evaluations are complete, but I've been contacted with an expert in this week. They told me that report will be 2 days later than the 21st of this month. Given the nature of that report, it's something that the state has time to look at and respond to and frankly decide how it wants to proceed. I've asked to continue the trial date to the 25th of September with the new office of the 13th. Mr. Teal is in custody, so we'll call and explain the stipulation very quickly, I guess. Your Honor, actually, I'm sorry. Because Mr. Jones will probably bring a chance to talk about it ahead of time, I don't think he wants to sign this today, so we may need to go ahead with it. And that's fine, whatever is easier. Yes, and I apologize. This is
The 19th, the trial date is the 19th, so I think we're going to need to roll it to a Tuesday or Wednesday next week, I believe.
Would be easier to address this in the courtroom this morning. I will do whatever is easier for the court.
Let's do Tuesday.
Initially appearing amused, Teal suddenly lashed out without provocation, punching his own lawyer in a shocking turn of events. The courtroom erupted into chaos as police swiftly subdued Teal and removed him from the premises, placing a spit hood over his head for restraint. Despite escaping physical harm, Birkland withdrew from the case following the assault, citing the incident as a reason for his decision.
Teal punches his own attorney.
Get down! Face down! Face down! Put your hand behind your back! Put your hand behind your back! Bring the chair. Bring the chair.
In subsequent court appearances, measures were taken to prevent further violence. Teal was heavily restrained, strapped to a chair to ensure his compliance and the safety of those present. However, even in this restrained state, Teal managed to voice a seemingly trivial concern about his appearance in his mugshot, questioning the source of the photo and expressing dissatisfaction with his hairstyle.
New counsel has been appointed since the last hearing.
I got one question, one thing to say. I'd like to know where the they got that photo of me with my short hair. Because that was on Facebook, and I don't have a Facebook.
All right.
So you're on it. Legitimate question. Like, do they have access to Google?
Ultimately, after a series of hearings and evaluations, Teal was sentenced to 8 1/2 years in prison, underscoring the seriousness of the charges against him. But this next case is more shocking than this one, where a suspect spits on Judge Webb. Bass Webb, a 30-year-old man, found himself in court facing attempted murder charges, a case that would soon reveal a series of dramatic and violent events. The initial charges stemmed from an incident caught on CCTV outside a Kentucky jail. Webb, a former inmate who had spent 3 months there on assault charges, intentionally drove his car into 2 prison workers. While one managed to dodge the vehicle, the other was not so fortunate. Webb was quickly arrested and brought before Judge Vanessa Dixon.
Accelerated his car and tried to run over 2 jail employees. One man was able to get out of the way, but one man was injured after Webb's vehicle pinned him against the wall.
Judge Dixon, knowing the 2 jail employees personally, recused herself from the case. However, Webb's reaction to her recusal was shocking. He spat at the judge, an act that led to immediate chaos in the courtroom. Judge Dixon charged Webb with contempt and had him removed from the courtroom.
I don't want to have to try this case or have any further proceedings, or I'll have to see you for one further setting. Set preliminary hearing next week. Charge.
The action clearly takes the judge by surprise. After initially dismissing Webb, the judge makes Webb stand and watch as she wipes the spit from her face. Then Dixon tells him she's seen enough.
Webb's defiance did not end there. While awaiting trial, he incited a riot among inmates at the Fayette County Detention Center. The disturbance escalated to the point where Webb was shot with beanbag rounds and hit in the neck with a pepper ball to subdue him. In retaliation, Webb swung a metal telephone box at a corrections officer, leading to additional charges. In court, the prosecution argued that Webb's actions were intended to cause serious injury, presenting the telephone box as a deadly weapon. Webb was found guilty of these charges and sentenced to 15 years in prison. Additionally, Webb was convicted of attempting to murder the 2 jail employees, adding another 37 years to his sentence. This brought his total prison time to 52 years.
If I were to launch this at someone 10 feet away, because this is capable of stopping that, does not mean that that is not readily capable of causing death or serious physical injury.
In a grim twist, another cold case came back to haunt Webb 5 years later. This time, it was the murder of another ex-girlfriend, Sabrina Vaughn. Sabrina had been missing since 2003, but her remains were discovered in 2010, buried in a shallow grave in Montgomery County. Webb was brought to trial for her murder as well. When Webb appeared in court for this case, he did so with a sinister tattoo on his head. The tattoo listed people he intended to kill. Webb was convicted of Sabrina Vaughn's murder and sentenced to life in prison with the possibility of parole after 25 years.
Webb, do you want to come forward?
You have found the defendant guilty of the offense of intentional murder.
His audacious acts and violent behavior both in and out of the courtroom shocked everyone involved and highlighted the dangerous nature of a man with a long history of criminal activity. However, the dramatic behavior of suspects in courtroom don't end here. On the night of June 18, 2006, Dexter Johnson and his gang allegedly carjacked 23-year-old Maria Aparice and her 17-year-old boyfriend, Ingo. The gang drove the couple to a secluded area where Johnson assaulted Maria. The ordeal continued as Johnson forced them into the woods nearby and executed both Maria and Hoy. Police traced the stolen car and found DNA evidence that linked Johnson to the brutal crime, leading to his arrest. In court, Dexter Johnson faced trial for these heinous acts. As the proceedings unfolded, the jury found Johnson guilty of capital murder. The presiding judge announced the sentence.
Dexter Darnell Johnson, the jury has found you guilty of capital murder. In accordance with the laws of the state of Texas, this court hereby assesses your punishment of death. Ladies and gentlemen of the jury, this is going to complete your jury service. I'm going to meet you in the jury room.
All rise.
Dexter Darnell Johnson, the jury has found you guilty of capital murder. In accordance with the laws of the state of Texas, this court hereby assesses your punishment of death. The verdict prompted a dramatic reaction. Johnson appeared to go into shock, unable to stand as the weight of the sentence hit him. Meanwhile, his family, seated in the gallery, broke down in tears. The emotional turmoil in the courtroom escalated when Johnson suddenly exploded in anger, causing pandemonium. Court officers struggled to restore order as Johnson was eventually subdued and removed from the courtroom. The chaos from the courtroom spilled into the hallway, where emotions ran high. One family member became so distressed that she required medical attention, and an ambulance was called to assist her. Despite the death sentence, Johnson's execution was later halted by a federal court. The court cited concerns about his intellectual disability, which paused the execution and placed his case under further review. As of now, Dexter Johnson remains on death row, his case still a topic of legal and ethical debate. If you thought that was bad, this is because you didn't hear about this case where a man outbursts on judge. Alto Miles became the center of utter mayhem during his murder trial in 2020. He allegedly killed 4 people in 2 separate shooting incidents, a spree that shocked the community and led to a highly publicized court case. Prosecutors detailed the chilling sequence of events, starting with the murder of his 35-year-old ex-girlfriend, Teal Mason, and 56-year-old Bridget Carter. According to the prosecution, Miles was provoked by jealousy after the women talked about photographs of other men on Facebook, leading him to snap and fatally shoot them.
All right, we're going to go on the record. Case B201832, case caption, State of Ohio versus Alto Miles. Mr. Miles is present in the courtroom today with attorneys William Welsh and William Oswald. Representing the State of Ohio today is Stacey Lefton. Mr. Miles was charged with a 6-count indictment, with 4 counts of aggravated murder, 2 counts of having weapons while under disability. Can we have silence, please? Pursuant to a hearing and a report generated by Dr. Stenson, the court struck the death penalty specification and found Mr. Miles suffered from 1 of the 4 required mental illnesses for that statute of schizoaffective disorder. And my understanding is there going to be a change of plea. Is that correct, Mr. Welsh?
That's correct, Your Honor. Court permission to revoke or plea not guilty, and then to plead guilty to counts 1, 2, 3, and 4.
The prosecution argued that this second murder was collateral damage, as the witness happened to be present when Miles sought revenge. Initially, Miles faced the death penalty, but in 2023, a judge ruled it out, citing Miles's mental health issues. Due to his unpredictable behavior, Miles appeared in court in a wheelchair with a spit mask on his face during his plea hearing. The court session was set to review a plea deal when chaos erupted. As Miles' attorney read out the new plea, Miles suddenly snapped, interrupting the proceedings with rants and profanities. Miles' rants continued unabated.
Along with gun specifications for each one of those counts for your gun specifications.
Shot my head, you shot me on my head. Stab in the face, stab in the next shot.
Ms. Lefton, is this a plea offer from the State of Ohio?
Yes, Your Honor. He's pleading to all of the counts involving all of the victims in this case, the 3-year tax it's the 1-year tax, 3 years back, and we'll get rid of the weapon under disability.
Counts 5 and 6?
Correct.
All right, okay.
The judge, seeking to confirm Miles' understanding and willingness to plead guilty, received nothing but vulgar and nonsensical responses. At one point, Miles shockingly exclaimed, "Motherfucker, kill me." Despite multiple attempts to calm him down and secure a coherent response, Miles' disruptive behavior persisted. His attorney tried to intervene, but Miles' profanities and erratic outbursts drowned out any sense of order. Eventually, the judge had no choice but to dismiss the plea and send Miles back to jail. Due to his behavior, another judge ordered a second mental evaluation of Miles. His case remains ongoing, as the court continues to grapple with his mental health issues and their impact on his culpability and ability to stand trial.
All right, Mr. Miles, is that your understanding? Is that the 4 counts that you're going to plead to? Mr. Miles, we set this hearing because, Mr. Miles, I have a documentation in front of me, an entry. To indicate your desire to plead guilty to 4 counts of aggravated murder. Is that true? Mr. Miles, I'm going to ask this question again. Last chance, Mr. Miles. Do you wish to plead guilty to these 4 counts of aggravated murder?
God. Come on, man, let's have a stop playing. You wasn't gonna like this stuff.
Mr. Miles, I asked
you man. You warning,
you intended to plead guilty to 4 counts of aggravated murder.
Skin of bronze here.
Yes? No?
Look at all the big you go 75 million motherfuckers are paying my taxes.
All right.
25 million
Take it back to jail. All right. Let the record reflect Mr. Miles cannot knowingly and voluntarily plead guilty to the charges that he's been indicted with. This matter will be reset. Thank you.
Hey, come on, we have a room. Let's go get that alcohol. Hold on. Have a seat. Have a seat. I just want to jump that comment there. It's all
Ladies and gentlemen, the hearing is not over. Please have a seat.
There you go. I want people to see you and listen to me. Y'all get the cameras out my face. Now I got my food to put no camera in my face. I got nothing to do with me. Flat out. Now it's a whole job.
Everyone needs to sit down and be quiet now.
That's all for this video. We hope you have enjoyed this video a lot. What are your thoughts on these dramatic courtroom moments? Let us know in the comment section. Make sure to subscribe to our channel and hit that bell icon for more interesting videos like this. Thank you for watching our video.